Common's website. Today, we have Signe Navy here to talk about building a solid IP strategy. Signe is an intellectual property counsel for Starbucks Coffee Company, responsible for trademark prosecution and enforcement for the United States, Canada, Mexico, Central America, and the Caribbean. She advises business clients on IP issues related to merchandise, social media, card, and domain names. She is a graduate at the University of Washington School of Law. Please welcome Signe.
I have to say I'm also, echoey. I'm also a graduate of Wazoo, so I'm a cougar, but I did go to UW for law school, and then I taught here for 10 years at the law school. I helped run the IPLM program here, and I guess a little bit more about my background. After graduating, I was a litigator at Perkins Coie. When I left Perkins, I came here to teach and also worked at Hughes Media Law Group, which is a small media law firm. And then now I've been at Starbucks as one of 4 IP attorneys for the entire world for about 3 years now. So this topic originally, as it was presented to me, was IP on a budget. And I thought, okay, I've worked at Perkins and UW and Starbucks. I don't know that I am the best person to really be thinking about IP on a budget. So I instead was thinking about my work with the Washington Lawyers for the Arts Clinic, the Entrepreneurial Law Clinic, some of the smaller clients that we had at Hughes Media Law Group. And so when I was preparing for today, I made a couple of assumptions. I made an assumption that the people in the audience, that all of you are either entrepreneurs or that you work with entrepreneurs. And if you don't, you will in the future, right? Fall into one of those 2 categories. I also made a basic assumption that you probably know just enough IP to be dangerous. Some of you more than others. And so with those assumptions in mind, I thought that what we would do today in our hour together is start with a IP 101. So we're all operating from the same place. And then we're going to turn off the screen, pull out the whiteboard, and do a little bit more interactive kind of problem solving and thinking about how different kinds of IP intersect with each other and how to think through developing a strategy for either yourself or for your clients, and really starting from the I have no money to spend all the way up to the sky's the limit. Okay, and it sounds like next week you're going to have a VC presentation. So maybe next week you start thinking the sky's the limit, kind of start thinking in that direction. Who has taken an IP class before? I know some people. Okay, who doesn't know what IP is? Okay, stands for intellectual property. And try to stand where you can see me. So we're going to go through copyright, trademark, trade secret, patent in about 20 minutes. And I'm going to give you, again, high level what I think is important for business people to know about IP. And again, you either already know just enough to be dangerous, or I'm going to give you just enough information to be dangerous. And then we're going to talk about how different areas of IP overlap and how you might prioritize developing an IP strategy. So what is a copyright? I was going to ask you, but now here I've showed you. A copyright is your expressive works. These are your creative works. Okay, so copyrights are your literary, musical, dramatic, pantomimes, which just means movement, choreography, pictorial, graphic, sculptural works, motion pictures, audiovisual works, sound recordings, and architecture. Sometimes people confuse copyright with trademark, but copyright are your expressive, creative works. And these pictures I borrowed, fair use, from the copyright.gov website. So it was kind of like my little joke to myself that I'm taking the pictures from the copyright website in order to show you examples of copyright. And this is completely a fine use of those pictures. So our literary works, performing arts, so you get the idea of what works are, what copyrighted works are. You may or may not care where copyright law comes from. I'm going to tell you anyway. It comes from the Constitution. Article 1, Section 8, Clause 8 gives us the basis for copyright law, and we'll see later for patent law as well. So Article 1, Section 8, Clause 8 tells us that to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So this is our foundation. It's a constitutional right to protect your intellectual property. Copyright is covered by federal law, and the requirements are that you have an original work, that it's fixed in a tangible medium, and that it fits under one of those categories that we saw on the previous slide. So original, I'm going to just take a moment and talk about what is original. For copyright, original is original to you. Okay, so we'll compare when we get to trademark and patent kind of how those differ. But it is possible for two people to be in completely separate rooms and develop exactly the same book painting software. And it's possible for both authors to have protection. Okay, there's no priority when it comes to copyright. It just has to be original expression. Okay, and that's very different from when we see the other areas of IP. That copyright, it is possible for two very similar works to coexist. Okay, as long as they're independently created, it's possible to have protection for both. Protection for copyright is pretty long. For authors' works, it's the life of the author plus 70 years. And this is something that has been extended over time. It used to be 50 years, and now it's 70 years. And as the Disney works start to get close to going into the public domain, we keep extending it longer and longer. So we might see another 20 years added on. But for now, it's the life of the author plus 70 years. So it lasts a pretty long time. Okay. So you need to have an original work, which again means original to you. And it needs to be fixed, means it needs to be permanent in some way, so it's not just something that's in my mind, okay? And it needs to fit under one of those categories we talked about. You can't copyright ideas. I could have the idea of painting a sunflower, okay? Scott could have the same idea of painting a sunflower. I can't stop him from having a sunflower painting. And you can't stop me from having a sunflower painting. We just have the same idea, but it's how we express it that gets the protection. My sunflower will probably look very different from your sunflower. Mine would not be very good, which is why I'm a lawyer. Okay, so what do you get with a copyright? You get the right to make copies of that work. You get the right to distribute that work. You get the right to perform that work. And you get the right to create other works based upon that work. Okay. That's what we're going to say about copyright. Any questions? Yes?
Should copyrights be updated, let's say, a user manual to like the current year, or should it be the copyright when it was originally applied for?
If there are changes, then you would have, your year would reflect that current version. Okay? It's not very expensive to file a copyright. Okay, $55. And copyright, the Copyright Office is more of a registration system, less evaluation, okay? Although if what you have is really basic, they're not going to take slogans, cliches, things that are closer to ideas. There is like a limit, but that limit is, there's a lot of latitude within copyright. There's not much evaluation that goes into your registration, to your application, which is very different from trademark and even more different from patent. Okay? Yeah?
Tweets.
What about tweets?
Because Lizzo just recently had to pay for somebody's tweet that was memed and considered their original work that she took for lyrics.
Yeah, so you have to be, so we'll talk just one moment about fair use. There are some misconceptions that because I have access to something and I've maybe changed it in some way, it's okay. It's okay for me to do that. And fair use is a broad defense for using someone else's work, but is not as broad as a lot of people think. Okay, so if you have used someone else's work, and remember, you have the right to make derivative works as the copyright owner. Okay, and so anything that is substantially similar to your original work, that person can stop you from using your own work. Okay, one exception is going to be if you create a work that's very transformative, right? So we want to have some breathing room for new creative works, but that breathing room is kind of out here. It's not in here, right? So if it's too close to that original work, then that original copyright creator is going to have that scope of protection. We want to be out here creating creative works that are different in character, different in nature, that use only a small amount, okay? And that aren't going to affect the market of the original copyright owner. Okay, let me move on to trademark, and we'll come back to copyright. But I do want to say one thing about copyright that will go into your overall strategy about copyright. You have a copyright by doing nothing. Just because you have created something that is original and creative and you fixed it, you have a copyright in that work. You have a right that you can protect. You have a right that you can enforce against someone else, okay? You put your little circle C and the year and the owner on that, and it lets other people know, hey, this is who owns this work. This is creative, this is copyrighted, and I'm the person who owns it, and here's when I created it, okay? So how much does it cost to do that? So IP on a budget, $0, right? It costs $0 to put a circle C and the year and the owner on a creative work, okay? So coming back to thinking about IP on a budget, if you file a registration, it gives you certain advantages, right? It gives you advantages. It's harder for someone else to claim they didn't know, right? You have a kind of seal of approval. It also gives you potential for additional damages that you could choose from if you were to enforce your copyright in court. So there are advantages. There are advantages to filing an application and getting a registration, but for $0, you have a right to enforce. Yes?
That answered my question.
Okay.
I was wondering why.
Yeah, it gives you a wider range of damages to choose from. And it's not very expensive, right? It's $55. And maybe you go to a WLA clinic, or maybe you pay an attorney $500 to prepare the application for you. Still not a very big investment to get some protection, but you have the right. You have the right, you have a copyright by just the fact that you've created something that's original and creative and fits in one of those categories, okay? So what is a trademark? This is most of what I'm doing day in, day out. How many trademark applications do you think Starbucks has? 30.
4,000. 10,000? 100,000?
24,000. We have 24,000 trademark applications, and that is because trademarks, like all kinds of IP, are limited to the jurisdiction, to the country where you want to protect that work. So you have to file. No such thing as a worldwide trademark. There's no such thing. Don't let anyone say, oh, I want to file a global trademark application. There's no such thing. You have to go country to country. I mean, there's systems to file in multiple places at once, but your protection is each country, okay? And your protection for trademark is also specific to the thing that you are protecting. Is it a t-shirt? Okay, is it coffee? Is it a can? Is it a table? All right, we've got multiple microphones now. Very exciting. Okay. So trademark is specific. I'll get into that a little bit, give an example in just a second. So what is a trademark? It is the definition is a mark, symbol, or design. Do I need a third one? Good? All right. So trademark is, I'm just going to get further away from the microphones. A mark, symbol, or design that indicates the source. So it tells you that something is coming from somewhere. Okay, so you see Starbucks and you immediately think that, okay, what I'm buying is coming from a particular place. It's coming from a particular source. It's coming from Starbucks. And then along with that, you probably have certain expectations as to quality, as to whatever is going to be consistent with the experience you've had with that brand before. Trademarks can last forever, as long as you're continuing to use them to sell something. Okay? You have to use them to sell something in order to maintain the protection. Okay, so some examples. Of course, I had to use ones that I'm near and dear to my heart. So it can be a word mark, it can be a logo or a design, it can be a name of a product, like a Frappuccino blended beverage, because we don't want it to become generic, but the Frappuccino is the trademark. Or this is our reserve branding, which is the star R branding for our reserve stores. So where does it come from? This is also a constitutional right. Okay, and it comes from the Commerce Clause, which controls goods that cross over state lines. And trademark is this fun area that has all sorts of different protection. It has federal protection, it has state protection, and I'm going to take one moment and try to boggle your brains and talk about common law. Okay, so trademark, similar to copyright, you can have trademark protection just by selling things and putting a label on it. Okay? You can put a TM on that. And that tells people, this is a trademark. This is my name for this thing. And you have rights. You have rights by doing that. You're putting people on notice. Now, we're going to assume you're not infringing someone else's rights, okay? But those rights are going to be limited to the geographic scope where you're selling that product, okay? So we call these your common law rights. You have the right to protection for that trademark where you're selling it. So if I'm selling something in Washington and I'm using a name on that thing, I'm calling it goobly goop, right? My goobly goop in Washington, and I put my TM on it, and I'm presenting it like it looks like a trademark, it looks like the branding on something, I'm going to have some protection in Washington. Okay? So again, thinking IP on budget, here's somewhere to start, right? Yes?
Do you have to put the C or have to put the T, or you have it anyways?
You have it anyways. In the past, in days of yore, you had to put copyright notice on things or you lost it. The law has changed since then. You don't have to put it on there, but it's easier to enforce. It puts people on notice, and it makes it harder for other people to argue they didn't know. I didn't realize that this was protected. So there's some benefits to it, and again, very, very low cost, right, to do that.
Real quick, can you repeat the question? Because we're live
Yes.
to our Spokane friends.
Yes, so the question was, do you have to put the copyright and trademark notice on something to get the protection? And the answer is no, you don't have to put it on there. In the past, for copyright, you did. And it was very, very strict. If you did not put the notice on there, you could lose it. That is not the law now, but there are benefits to putting those notices on there. Harder for someone to argue, didn't know, good faith, couldn't find the person, didn't know who owned it, right? So it gives you those, there's a lot of benefit and very little like transactional cost to putting it on there. Yes?
What if you go beyond the US and have like an international distribution network?
Okay, so international, under the Berne Convention, there are going to be certain recognitions of copyright in places outside of the United States if you have protection here. So you should still put the circle C on international distribution. TM is going to be your baseline protection. It will be recognized international as well. Do not put a circle R. Okay, very important. Do not put a circle R because that is only when you have a registration, right? And the registration has to be in each country for the particular thing that you're selling. So TM, pretty safe. Okay, circle R, you only can use that when you have the registration.
How long does that process take?
It's going to vary from, so the question was how long does the process take? And it's going to vary from country to country. I'll say about 1.5 years in the US. Year, maybe if things go smoothly. Internationally, it can take longer. It depends on each country takes different amount of time. Okay? Yes?
What's the definition of selling? Like if you have a product that people are using for free, is that?
Okay, so this is a great question. What is selling and what is what we would call under trademark, what is use? What is use in commerce? So you'll hear that phrase. What is use in commerce? You have to be offering someone for sale, so there has to be some kind of consideration, some kind of price attached to it, and they can purchase it, right? So if I'm just advertising something or I'm just talking about something on my website, but no one can buy it, that's not really use in commerce.
What about if it's like a free digital product, for instance?
If there's some other consideration, which means there's some other price, then it might be a use in commerce, okay? And there are manuals that talk about what is use, and so that's something that for the particular thing, you probably would want to get a little bit of advice on that, whether that particular use would be considered use in commerce. Okay? Okay, so TM, I'm selling something, I get protection in this small area, but if I file a trademark application, a federal trademark application, and I get a registration, and there's an examination process. Okay, so this is different from copyright. There's actual examiners who examine the trademark. If you get that registration, we know one thing you get to do, right? You get to put the circle R. Yay. You also get nationwide protection. So even if I'm only selling the product in Washington, I get protection in the entire United States, right? There's a presumption of nationwide use. You get protection everywhere. And after 5 years, then it becomes harder for people to challenge it. There's this presumption kind of validity or incontestability that makes it harder for someone to challenge your trademark. Okay? So the application process, it's about $275 for the application per class, okay? So trademark is broken up into different categories. So there's a class that is for clothing. There's a class that is for like paper goods. There's a class for entertainment services, right? So you have to file for a particular thing in that particular class, in that category. And it's very narrow that you get protection for that thing, yet use on that thing. Each class is $275. Okay, so if I wanted coffee and restaurant services, I would be filing in 2 classes. If I wanted to add on mugs and tumblers, I'm filing in a 3rd class. T-shirts, another class. Okay?
Do you typically recommend filing both a stylized and an unstylized?
Okay, so the question is, do I recommend filing stylized and unstylized? Lowest common denominator is just the word without stylization. That's going to give you the broadest protection. So I would always start there, because you can take that word and present it in any number of ways and still protect it. The stylized is only if that's really something special and what you want to enforce is more that stylization, then there's consideration for doing that. But on a budget, start with just the word. Okay? Start with just the word. That's going to give you the broadest protection. Yeah?
For really strong brands like Starbucks, can I go and file a trademark application for Starbucks branded like boats, for example?
Yep.
Or does the law kind of recommend that such a powerful brand drafting off of the create confusion?
Drafting. I like the use of drafting and boats. And so the question was, what about, like, let's say a famous mark, but maybe in an area that it's not protected in. Okay, so let me start. I'm going to go back to this slide for a second. So it is possible for multiple trademarks to exist. Okay? And this is my delta, delta, delta example. That it's possible to have delta on faucets and delta on airlines and delta on dental. Very distinct goods and services. Consumers are not going to be confused and think that Delta faucets are offering your dental services. Okay? So it's possible to have the same name on different goods or services if people won't be confused by it. Okay? Now when you have a famous mark, that halo kind of goes a little bit broader, right? The less famous you are, kind of the narrower you can protect. But if you're famous, then it's more likely that someone is trying to build off of your goodwill. And there are international treaties that are interpreted differently in different countries, that some of them protect famous marks beyond that narrow channel. So we have been able to find famousness for Starbucks and also for Frappuccino in some jurisdictions, so that someone else couldn't offer a Frappuccino lip balm, right? Because they're trying to build off of our goodwill. But I've also seen a Starbucks towing. There's a local Starbucks towing company that we've looked at, and that's the person's name. And they do towing. And there's nothing that we can or will do about that, because people aren't going to be confused between the towing and the coffee. And there's a legitimate use for it that's not just taking off of our goodwill. Okay, but if Starbucks towing started having like sirens and green and concentric circles and all sorts of things like coffee cups that look like us, then we think, oh, okay, they're trying to build off of our goodwill in order to promote their company. Okay. Yes?
If you have it registered, do you have to display the little R or?
Okay, so the question is, do you have to, we call it bug. Do you have to bug your word? Do you have to mark it once you have it registered? And we have a lot of internal debate between the marketing team, who doesn't want to bug anything because it doesn't look cool, it's not user-friendly, right? That's not how millennials engage with their brands. So we have a lot of debates about the marking. Our rule of thumb for our company is to mark everything, because it puts people on notice. It makes it harder for a mark to become generic, so that we might lose it. So are you required to? It's kind of debatable. You're not going to lose it in the way with copyright in the past you would lose it if you didn't mark it. But it's easier to lose, and to lose its distinctiveness, if you aren't marking it. Okay? Okay. So I don't want to overwhelm you guys too much. So again, it's possible to have the same mark in different places, but it's not permitted if people might be confused, if consumers might be confused. And these are the factors that we look at to try to decide, would people be confused? Most important are two of them: similarity of the marks. How close are the two marks to each other, right? Do we have Starbucks and Starducks? Or we have Starbuzz and Starbuds and Starbox are all ones that we enforce against. How close are they visually, right? How similar do they look? How similar do they sound? And how similar are they in meaning? Okay, so you might have a cyclone fence and a tornado fence, different in sound, similar in meaning. So would a consumer go to a store and be like, oh, I want that thing that's the, and they can't quite remember the word, but it has a similar commercial impression? Then there might be confusion. Okay, so that's and I'll put that all into one, similarity of the marks. And then how similar are the goods, right? Are we talking faucets and an airline? Or are we talking a t-shirt and a sweatshirt, right? The closer that the goods are in similarity, that's gonna weigh more heavily that consumers might be confused, okay? And then there are a lot of other factors I'm not gonna go into. I don't wanna I've been told that sometimes I teach like you're drinking from a fire hose, so I'm trying to turn off the fire hose a little bit. Okay, so federal registration, you can also get state registration, right? It's pretty easy. In Washington, it's more similar to like a copyright application. You can call someone up at the Secretary of State for Washington and be like, hey, is there Starbucks do you have a trademark registration for Starbucks in Washington? And they could be like, no, we don't. Okay, great, I'm gonna file this. And it's pretty easy, it's pretty quick, it's pretty cheap, but it only gives you protection in Washington, right? So it's pretty limited, but if we're thinking about IP on a budget and you wanna start somewhere and you wanna have some seal of approval, some certificate that shows that you have some rights, this is a really cheap place to start. You can do it yourself. You don't need an attorney to do it. It's literally just like a 2-page form that you fill out. Okay? Yes?
So you're saying with that you could put the little R there so people might not know.
Then you still have to put the TM. It's still a TM because it's a state right, so it's more like a common law right. But you have this certificate, you have this registration, you have this proof that, it gives you something, right? It gives you something legitimate. Okay, so IP on a budget, thus far, for $55, you could have copyright protection and trademark protection. Put your TM, put your Circle C, file one application, just, thinking about somewhere to start. For the federal application, you probably need some help filling it out. Okay, you need someone who's going to be able to represent you in the trademark office, but you can often find people that aren't too spendy. Okay? Okay, so let's talk about trade dress, which is a subset of trademark. So if I described to you a robin's egg blue box with a white ribbon. Tiffany's. I like to see which men know this one, because then it's like, okay, you're doing great. So a blue box, a light blue box with a white ribbon, doesn't have a name on it, but just from seeing that box and that packaging, you can identify the source. You can identify where it came from, right? So it's serving like a trademark. It's serving as a source identifier without having a word or a logo or a symbol on it, okay? So you can have rights in that trade dress, but frankly, they're harder to protect. It can be hard to define what it is specifically that you have that you're protecting, okay? But it's something to consider when you're thinking about the whole panoply, thinking about your whole range of IP, that you also can have protection in that packaging, right? Or in the specific design that you're also selling your goods or services under. Trade dress will not cover things that are functional, okay? So if the packaging, let's say, had a zipper on it, okay? You're not going to be able to protect that zipper if it serves a functional purpose, okay? And we could go on and on and on about that. Very exciting. How do you obtain protection? You can also register trade dress with the PTO, but again, it can be harder to define to the PTO what it is. So often you rely on your common law rights. Again, are those rights that because you're using it and selling it, and then those rights would be limited to where you're selling it. Okay, but it's something to think about as you're thinking, as you're going through, what do I have that I could protect? It's in that whole arsenal of things you could protect. Okay. Trade secrets. Guess what? Also free. Also free to protect. So what is a trade secret? A trade secret is anything of commercial value, not generally known by the public, that you have taken reasonable steps to maintain its secrecy. Okay, you've taken reasonable steps to maintain its secrecy. And it's protected under state law. Okay, there's also now a uniform federal law, but historically it's been state law protection. Do you think you file your trade secrets? No. Would that kind of undermine the whole purpose of it being secret? Yes. Okay, so a trade secret is something that has value that you keep secret. So what do you think are some examples of trade secrets?
Recipes.
Recipes. So like the Coke formula. What else might be a trade secret?
Some technology exposed.
All right, so technology that you don't want to expose to the public. So kind of like what's on the back end, what's in the black box. What are some other things? Trade secrets can be a really powerful category of IP.
Do like ongoing research and development, like
So,
projects?
yep, so research and development. What about like customer lists? Yeah, is that what you're going to say? All right, I could just read your mind. Customer lists, right? Things that give you an advantage. What is it that gives you an advantage? And it gives you an advantage because other people don't know it, right? It could be data that you have collected. It could be demographic information. It could be customer lists. It could be recipes. It could be formulas. There are a lot of things that have value because you keep them secret, but guess what? They only have value as long as you keep them secret, right? So here's some examples. So reasonable efforts can be physical barriers. They can also be legal barriers. So they can be card key access. They can be actual physical barriers to seeing those secrets. They're also legal barriers. That's where you have your non-disclosure agreements, your confidentiality agreements. That's why you'll see sometimes when you go to visit a company, they make you sign, they now make you like sign a little electronic form or paper form before you can go in and take a tour. Right? So it can be both. It can be both the legal barriers and the physical barriers, but you have to try to keep it secret. Okay? Because once, if you haven't made that effort, then it's out there. Okay. It is possible for someone else to reverse engineer your secret. Okay, you can't stop someone from reverse engineering, from taking your recipe, from taking your product, trying to figure out what the pieces were in it. Okay, you can't stop someone from doing that. But let's say it's someone you had a relationship with, a business relationship, and you're sharing information with them. Okay, then you could stop them because you had a special relationship and hopefully you have your confidentiality and non-disclosure agreement with them in place. But someone unrelated to you could go out and like reverse engineer and tinker and figure out your secret. Having a trade secret as IP doesn't keep you from that other person doing it. Okay, makes it harder, right? And it also protects the people who you might be entering into relationships with, that you're sharing that information with, that they can't then use it outside of that relationship. Okay? So trade secrets cost nothing, have value, but you have to protect them. You have to keep them secret. Okay. So finally, yes?
How do you enforce that if you don't have to file paperwork or anything? Or how do you claim that it was a trade secret that was leaked?
Okay, so how do you claim that something is a trade secret? We'll start with the obvious one. If it's someone you had a relationship with, and let's say you're developing some special software with them, your relationship falls apart and they go out and release, lo and behold, the same software. Because of that relationship, you would have a basis for believing that they used the secrets that you shared with them. So that's the easier one when you have that relationship, okay? If it's someone else, then there's that question, could they reverse engineer it? And they're gonna have certain protections, have those, I guess, those defenses of reverse engineering. So most of the situations are people where you've had some relationship with and you've shared those secrets with them, okay? When you're in court, you can file things under seal so they're protected so that they don't then get disclosed to the public, right? So you can take steps if you're enforcing it to still keep it secret.
One of the beginning steps for any product development is to create an MVP, a viable product that you can kind of test with users. At which point you're kind of giving out your ideas. You're still in testing mode. You probably have not even developed 10% of your product, but your idea's out there. And I struggle with that. Most people say, working on your idea is the biggest thing here. You don't have to worry about losing, but then it still feels like there must be a little bit more than that.
There's a trade-off, and I suspect that your venture conversation next week might talk about that a bit. What are the agreements that you want to have in place before you share anything, right? You want to have your non-disclosure agreements. You want to have confidentiality agreements. You want to have these legal barriers in place before you share those ideas, okay? So one of the things that I am responsible for at Starbucks are unsolicited solicitations. So people that have these great ideas and they want to share them with you because they want you to market them. And we say, okay, go to our idea submission portal, which makes you kind of click through and say, if I'm sharing this with you and you happen to come up with a similar idea on your own, then I can't enforce this against you. So like I'm sharing it with you knowing you might have something similar already in the works, okay? So you have to protect yourself from both sides. So like from Starbucks side, we have to protect ourselves from people coming and giving us these ideas that we might not want to know. We don't want to know, we're doing these other things over here and we don't want you to think that they're related. But from the entrepreneur side, you want to have these confidentiality agreements in place before you share these ideas. So it is something that you have to weigh very carefully. And if you're thinking about a trade secret and you're sharing it without those protections, you're not going to be really protecting it as a trade secret, right?
I feel like when Starbucks came up with the pumpkin spice latte, I feel like it was a pretty original idea and recipe. But then if you look at a lot of other coffee shops now, they all have that. It might not be the exact same thing. So how were you guys able to protect it in any way?
So we have a trademark for PSL. So we do have a trademark for PSL, but pumpkin spice latte itself is descriptive. So you can't trademark names that are descriptive of the thing itself. So lemonade, right? Orange juice. And I would put in that category pumpkin spice latte. It's very descriptive of what you're getting. And so trademark doesn't really give you protection for those kinds of terms. But we were able to trademark PSL. We can protect the recipe, and we do protect the recipe itself. And we will protect if someone is using other elements that kind of trade off of Starbucks. So right now, there's a beer that is pumpkin spice latte beer, and it has this logo that, lo and behold, is concentric circles and looks very similar to us. So once you see those additional elements, then you're trading off of our goodwill. But the name pumpkin spice latte, the idea of a pumpkin spice latte, we can't protect that. We can't own that.
Also, as a follow-up, so if you have okay, so let's say there's somebody who's working as a barista in one of your shops, and then let's say they quit and then they open their own coffee shop, and then they're basically using the same recipes that they learned from working at Starbucks. How would you deal with that?
So the question is, what if someone quits and goes somewhere else and they have certain know-how that they're taking with them? So this is more of an employment issue. What was your employment agreement? Do you have a non-compete clause in your employment agreement that will limit you going somewhere else and using very special information that you had in your current employment to in your later employment. So that's more of an employment issue, looking at non-compete clauses. And you can take with you certain know-how, like, oh, I know how to make a latte, okay? We can't stop you from going somewhere else and making a latte. We could stop you from using that trade secret if we have a special formula and a special trick to making the pumpkin spice latte that we're protecting and that's unique and has value, then you couldn't go somewhere else and have that really special thing that might be a trade secret.
How would you know?
Sometimes it just comes to your attention like, hey, Barista John is over here now doing this thing. I went to this other store and I saw him, so there are a lot of tattletales out there that like to share. In fact, we have a whole alias that's called copycat. So copycat@starbucks.com. You can send anything you see out there and it actually comes to me. So we get a lot of stuff that way, like, hey, I was in, this place and check out what I saw.
How specific does your non-disclosure agreement have to be? Like, I can imagine you go somewhere and they give you a blanket one. Does that cover anything? Like, does it have to?
So usually you're going to have like a definition of trade secrets. You're not going to write your trade secrets in it because then that's probably not a really good idea that you're like sharing very specific things. But you can, like, if you go online, you can find 1 or 2 page non-disclosure agreements that just say anything that's shared in this meeting is going to be confidential. If you're worried about something being protected, you mark it confidential. Do not share. So that's always a step you can take from the side of sharing. If you're sharing the information, mark it, identify it, and then have in your NDA anything that fits this general category or is marked in this way falls under this agreement. So you kind of covered both bases.
I had a couple questions.
Yep.
One, just from what you just said, do you recommend a confidentiality agreement in email footers? Do those even hold up? Or
So
not the agreement, but just like everything in this email is confidential. Is there any case behind that? Where that's
So the question is kind of what's the value to having confidential in a footer on an email? It puts people on notice, and that's always helpful. In the same way that having the Circle C puts people on notice, having the TM puts people on notice. Marking something as confidential can put people on notice. Is that in itself enough? Probably not, but it gets you, with no expense, gets you somewhere, right? Gets you, some at least putting someone on notice that they can't say, oh, I didn't know. Maybe they can argue it didn't matter, but they can't argue it didn't know. They didn't know.
And then my other question, you kind of touched on it. I was just curious how Starbucks does it, but like operationally, how do you monitor your patents and your trademarks? And you said that you have a website where people, out of their own goodwill, submit stuff. Do you have any other methods that you use?
So for enforcement?
Yeah, just like how to know what's going on.
Yeah, so the question is, like for a big company, are there enforcement tools? So we've recently begun using a company called Yellow Brand Protection. There are a lot of companies out there that offer kind of search strategies and algorithms that can identify uses of I'll say trademark, because that's what I'm looking at. And we're just a month or 2 in, but the benefit is that it can get much broader than we can through our copycat alias or through other means. And the other benefit is that over time it's going to help us to aggregate information, so we get a better sense of where there are connections between, let's say, counterfeiters, where I might see one website and I see a different one, but I have no way of knowing they're connected to each other. If you have a platform, you start being able to connect those dots and say, oh, okay, I thought this was no big deal and I thought this was no big deal. But now I'm seeing that there are a lot of these that are actually connected. And it's for enforcement, that can help you drive your strategy as to like, where is it worth enforcing? So there are tools out there. They're going to cost money, Okay, other questions? Before we move on to patent, which you have to pay for. Okay, so I'm ending with patent because you can get copyright, trademark, trade secret protection literally for free. It may not be the deepest and broadest protection, but you can start there. Patent is going to be, these are your inventions. Okay, patents are inventions. In order to have protection, so light bulbs and mechanical things and pharmaceuticals, also protected under the Constitution. It's the source of the law, and it's federal protection. This lasts the least amount of time, 20 years, right? It only lasts 20 years, but that's because the protection you get during that 20 years is really strong. If you are the first person who has that patent, I don't care if someone else came up with the same invention in their own garage, I own it. And I can stop you from using that same invention. Okay? Whereas trademark, remember, as long as people won't be confused, we can all coexist. Copyright, as long as we came up with things that are original on our own, can coexist. Trade secrets, as long as they're secret, we could have the same secret and not know each other, not know about the other one. Patent, there's only one winner. Okay, so this is why it's the most powerful. It lasts the least amount of time, but it gives you the greatest rights to exclude other people from it. So something to be very careful of as we're thinking about IP on a budget, you have a window of time to file that patent. Okay, you basically have 1 year from the time that you're sharing it in the public in any way, and what is public disclosure has gotten much broader in the last several years. So as soon as it's like not just in your secret lab and you're sharing it in some way, that clock starts ticking. Okay, that clock starts ticking and you have 1 year to file that trademark application, or you lose the right altogether to file it. Okay, but if you get that protection, you can keep other people from doing the same thing, even if they came up with it on their own. Okay, and patent is the one area that requires that you have, to file an application, you have a science degree. Okay, so it's the one area that has, within our legal system for lawyers, only a subset of lawyers can be patent lawyers.
So science degree being like master's and PhD, or if
It can be broad. Scott, can you, yeah.
A bachelor's is fine, and sometimes just a certain number of hours will qualify that, but as the inventor, that's not the requirement. Like if an inventor themselves filed their patent, there's not that requirement. It's only for the attorneys that are going to be representing you to file it. But I will say hire a patent attorney and don't file it yourself.
Right. So, ergo.
As an inventor that you have any sort of technical degree or anything like that. But use, for all of these, contact an attorney.
Yes, yes. So yes, as the inventor, you can file it, but recommended that you get some help, right? Okay. Okay, 1 year. So application fee is about $300, but again, this is something that you want someone to help you with. Okay, so I'm gonna turn this off now. I'm ready for the whiteboard. I'd like a cookie. Ah, darn it. Yes.
I have a question. This is kind of not related, but I know that patents, they expire after however many years, but then people can buy expired patents? Is that, no? Okay, cool.
You can't buy expired patents, but you might have licensing rights still. So sometimes people will control their invention through licenses. So let's say I have licensed this technology to you for 10 years, but my patent expires in 5 years. Even though the patent's expired, I still have a license or that's controlling the use of it beyond the life of that patent, but I don't have the patent protection.
So the person that signed that then didn't know that they only had to pay for a license for 5 years.
Maybe they didn't have a lawyer.
All right.
Or maybe it's part, maybe for business reasons it made sense.
Copyright.
Yes.
It's So author plus 70 years, author's life,
Life.
Life plus 70. Can a company file a copyright?
And then it's, I think 125 years from the date of publication. It's either 95 or 125. 95, okay.
Okay.
Yeah, so it's 95 from the date of publication. You can have a corporate author.
Okay, so it isn't the life of the company.
It's not the no, it's not the life of the company.
Okay.
Then copyright would go on forever and ever and ever. Yep.
If you're looking to trademark like a company name, Starbucks for instance, do you have any burden to prove that people actually know about it, and what is that?
Yeah, no, this is a great question. So if I want to file a trademark and get trademark protection, do I have to prove anything? Okay. And I had skipped the slide about different kinds of trademarks. Not all trademarks have the same value. Not all trademarks are the same. So trademarks that are made up words, okay, you don't have to prove anything to get protection for it as long as there's not something that's confusing to it, okay? So if I make up a word and I want to do my gobbly-gobbly-goop, right, and I want to do it on coffee, and there's nobody else who has that, I don't have to prove anything, I can file it, etc. For words that people know, but I'm using them in unusual ways, so Apple, you guys all know Apple, but I'm using it on a computer, so common word, uncommon way, as long as no one else is confusing, I don't have to prove anything. Words that are suggestive, so you have to like pause and kind of think for a moment, and then you have that aha moment where you're like, oh, I get the connection. So I like to use the example of chicken of the sea. Is it chicken? Do you know what it is? It's tuna. Sorry, I think I just spit on you. I'll step back a little bit. I was a little excited. It's tuna. So you have to like think about it. It's not descriptive of what the thing is, but it's not a common word used in an uncommon way. It's not a made-up word, right? But it's suggestive of something about the thing. Don't have to prove anything. Okay. Descriptive words may or may not be trademarks. Okay, and when we're in this world, then you have to prove that people make the connection between the word and the source. Okay, so Seattle's Best Coffee. Descriptive. But we have a trademark for Seattle's Best Coffee because we were able to prove that there was a connection between people saw Seattle's Best Coffee and were thinking, oh, there's one source that I'm thinking of for Seattle's Best Coffee. So if you're in that world where it's descriptive, this might be pumpkin spice latte, right? Descriptive, but maybe we could prove that when people see pumpkin spice latte, they're thinking it all comes from Starbucks. Maybe then we could protect it. Okay, but though in that situation, you do have to prove it. Okay, so you might end up going on what we call the supplemental register, which is sort of like the B team. And you can go there while you're trying to prove and gain market recognition, and then submit that evidence, and then try to move on to the principal registry. Yes?
Which one are you most proud of? What are you most proud of doing at Starbucks?
At Starbucks? What am I most proud of? All the coffee I've drank? I don't know. Like, it's really...
I wasn't sure if there was like some cool evidence.
Yeah,
that
no,
you
let me think
proved
about
to
this for a
get
second.
one.
But first, I have to say, I did the Coffee Master program, and that was really cool. And I loved just learning about coffee, and that was really fun. So I'm proud of that, but that's not really what your question is. So,
I didn't know if you'd like finagled something to the kid.
oh, I'm not going to tell you what I finagled. That's all
Secret.
top secrets. Okay, we're on number 3. Is this on now? Okay.
Signe,
Yes.
were you involved with the Dumb Starbucks?
I was not. That was right before I started there. I was involved with Unicorn. I am involved with Siren's Blend. I am involved with Balmacino. All sorts of fun ones that are out there. I am involved with Starbuds, and I can't talk about any of them right now. I think that, okay, so I think what I'm most proud of is something that doesn't get attention, which is that we don't get sued that often. So we spend a lot of time on clearance, and we didn't even talk about clearance today. Clearance is trying to see if the trademark is available, is trying to see if the patent is available. You know, there's a huge part of clearance that we didn't even talk about because I was trying to tell you everything you could do for free. Clearance is not really going to be free, but you can do like Google searches on the Google platform. I don't want them to lose their trademark. You can do searches on the Google or Bing or whatever platform you want to use just to see if someone else is using that name. But 99% of the time we're on the offensive, and I think largely because of all the clearance work we do to try to make sure that names and things are available for us to use. So I think that's the thing that's like I'm most proud of, because usually we're usually able to be on the offensive in a very polite, gentle way, not in a trolley bully way. Okay, yes?
You sell camera straps that work with like Sony and Canon cameras. Can you run online ads with their logo or name?
Wow, that's a really specific question.
In general, like, you know, or like a GoPro adapter. Can you use someone else's name and logo in your ads?
So there's a doctrine called nominative fair use and descriptive fair use. You can use someone else's name if you're using it in a descriptive way. My camera strap is compatible with this product. And then you might want to have a disclaimer like we're not endorsed by them, affiliated with them, etc.
Gotcha.
I would steer clear of anything that makes it look like you're a co-venture, co-branded, associated, sponsored. So someone can say, I love Starbucks coffee. I sell Starbucks coffee. There's not a lot we can do about that, but if you have the siren logo on there and you're like, come to our store, and there's this big siren logo, then we're gonna say, no, because now it looks like you're one of our licensed stores or you're one of our food service accounts. And people will be confused by that.
Gotcha.
But you can use trademarks descriptively.
We do one more question.
Okay.
So you didn't talk a whole lot about design patents. I'm just wondering if
Oh,
you
yeah.
could briefly go over design patents,
Sure.
their relation to trade dress, if there's any.
Yes, so funny. The question was design patents, and I had actually added that into the slides and then took it out. So design patents are a subset of patents that are not utility patents. So they're not your inventions that have that you typically think of with a patent, but it's something that's ornamental. So it's more similar to trade dress. Okay, so the benefit of filing a design patent is that then you're going to get that exclusivity with it. So like Uggs have design patents on like their shoe design. Okay, so there's some, as long as it's not functional, right? So it's something that's ornamental, but if you get the design patent, it's gonna cost more money to get it. But if you get it, you're gonna have that exclusivity that gives you more guardrails and easier to protect than trade dress, where you're probably relying on your more common law description of something. Yep. Okay, I think.
Sorry, we're going over and I need to respect your time. So.
It's okay.
Thank you very
Yeah.
much.